Your Ladyship, the sole purpose of conservatory orders under Article 23 of the Constitution, which gives this court power to issue conservatory orders, is to preserve the substratum, the subject matter of the petition. Here, what is being preserved is the right, constitutional rights of the Deputy President, who has challenged the impeachment for violating his rights, seeks to have that impeachment vacated and quashed. That is what needs to be preserved, and that is the purpose for which 3 judges issued conservatory orders, or 2 judges issued conservatory orders. But, my lords, your ladyship, those 3 judges sitting separately, each one of them made a finding that there were serious, weighty constitutional issues raised that needed to be fully canvassed during the hearing of the petition, for the court to have the opportunity to give a considered decision on those issues, and therefore gave conservatory orders to preserve the subject matter, so that the Deputy President remains in office. There is no vacuum, there is no insecurity. My Lord, the best guarantor for security is observance of the rule of law, constitutionalism, and the Constitution. And this is the court that has that weighted duty of ensuring that that happens. My lords, the weighty issues identified by the 3 judges are: 1, the issue of public participation. The petitioner here says the public participation was a sham. We will be going into that through my colleagues. I'm just saying the weighty issues here. The second issue was the constitutional validity of Standing Order 68, giving a period of only 12 days to finish the whole purpose of the impeachment. And I would like to mention this issue of public participation, and indeed the time of 12 days, assumes added importance when we remember the wording of Article 1. The wording of Article 1 is that sovereignty remains in the people of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof, the threshold, serious violations of the Constitution, which the Deputy President says do not exist in his piece. Our opponents were pointing out to you where it is that undermining the President is one of the grounds. But Lord, the people of Kenya maintain sovereignty in themselves. Elected leaders, members of Parliament, senators, deputy president, the president, to serve them. They are employers. The deputy president, the members of parliament are employed by the people of Kenya. And therefore, the people of Kenya have got a right to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords, your leadership, to be the bench, what the judiciary is, what the people of Kenya look up to hold the country together in terms of observance of the Constitution and the rule of law. The people of Kenya, in electing the deputy president and the president and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. It is for this to ensure that we do not go back to the imperial presidency where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague Elisha Ngoya.